Okay, hi guys. So for this lecture, we're going to be discussing duty of care in further detail, but mainly in relation to public authorities. So this can basically be linked back all the way to Hill and Chief Constable for West Yorkshire, if not even earlier. So it's basically done on the grounds of public policy. It's saying that if we're going to allow public authorities to have all these claims against them, that money basically, you have to realise it goes from the government. And that's a big problem because that money is meant to be, so say one person claims against the police lose all that money from the government. What about all the other people that this government's meant to be looking after? And so it doesn't really want a lot of claims against public authorities, and you could argue that that may be a reason that they've introduced blanket immunity, if you think blanket immunity is or was there at some point. And in Hill and Chief Constable, it basically was, they didn't allow the claim for fear of defensive policing or for claims to flood in. So they don't want the police to be scared to do their job. They want them to move forward and do everything as they're meant to do, follow procedure, not hold back and not do a lot of things out of fear that they're going to be sued. So this whole idea of blanket immunity, I think you have to find your own opinion as to whether or not it was there. I personally believe it was basically there. They had this sense of blanket immunity to protect them. So in the Hill and Chief Constable of West Yorkshire, it was discussed in the previous lecture. It's the one with the Yorkshire Ripper. He was released and then he went on to kill again. That case, they said, we're not going to allow this. It was too large a class to make the police liable to look after. There was nothing to signify it was going to be her who was murdered, all these things. That case I understand. However, this case is the reason for a lot of the cases which followed and the reasoning behind them. So cases which support that there was a blanket immunity, you can look at Hill, Van Cole and Smith. So in Van Cole, there was a witness who was going to testify against someone, a criminal. I think he had like a lot of theft, maybe arson, something along those lines, but nothing quite major. And he had been threatened by this person, saying that if they testify, they're going to hurt him, his family, etc. And this had been mentioned to the police. Police didn't really do anything, didn't give him any extra protection, nothing like that. And then it later went on and he was shot. And the courts argued that because of the fact that it was smaller crimes, there was nothing to say that the police could foresee that he's going to go on and shoot him. It would be like attempted murder, such a great crime. It was unforeseeable, and so you can't find the police liable for this. However, when you look at a case like Smith and Chief Constable of Sussex, it seems a lot more like there is a blanket immunity. In the other cases, you can argue there was a bit of room for them to argue otherwise. However, in Smith, he has an ex-boyfriend who kept sending him violent threats, messages. They were extremely explicit, and he'd shown the police, he'd contacted them multiple times. He was being harassed to a great extent. Police did nothing about it, no arrests, anything like that. And later on, his ex went on to try and kill him. I think he attacked him with a hammer or a hatchet in his head, and he managed to survive. So it was basically attempted murder, and it would have been murder if this man had died. And he'd gone to the police various times, and nothing was done about it. And they used the reasoning behind Hill to decide this in the Caparo criteria. They said it wouldn't be fair, just, and reasonable to impose this liability, and so they didn't. So you can look at these series of cases and say, okay, the police have made so many mistakes and they haven't been found liable for any of them. There is this blanket immunity. However, I say the courts have moved away from that greatly as a result of Robinson and Chief Constable of West Yorkshire. So that was when they were going to arrest a criminal, harmed a citizen in the process, and the court said it's irrelevant that it's the public authority. All are equal in the eyes of the law. We're all to be held to the same standard. We're all liable for the same things. And this has been supported by Sumner and James Bowen, showing that this is the direction the courts are moving in. You're no longer protected by the fact that you're on a public authority. And you could argue that this could be a bad thing. So if you're looking at essay questions, you may have to argue this is a bad thing or if this is a good thing. So you could say it's bad because it allows so many claims. This money is going to go from the government. Our resources will go down if these claims succeed. However, at the same time, you can say that it's one of the rules of law. We're all equal in the eyes of the law. And so the loss of this protection is a good thing because it means maybe the police will have to ensure that they don't act in a way where citizens would be able to claim them. If they're acting in a manner for a claim to arise, that claim should succeed. Okay. And a lot of times, such claims would be struck out. So in the earlier cases, it's a public authority. The courts have this precedent where it's not fair, just and reasonable to impose this liability, and so they won't. And a lot of people are saying this is conflicting with our Article 6 rights, our right to a fair trial. You're just striking out our claims. We don't get to court. We're not getting that fair trial. However, in UK, it was said that if your claim is struck out after consideration, there isn't an infringement because the law's already been decided, that precedent exists, it's already been enforced, and there's no reason for us to waste our time and our resources and a lot of money into a case where we know what the outcome would be. We can also discuss Weichel and others, where it was said that people should stop trying to shape our normal rights with human rights. They're separate things. We don't need to increase the scope of liability for negligence, keep them separate from one another. Okay, another thing we can look at are child abuse cases. So in Barrett, he'd basically been in care of the local authority from the age of 10 months, so not even a year old, and they were very negligent in looking after him. I think his social workers kept changing, all these things, he kept moving about, and this negligence caused him psychiatric harm. And the question was whether or not the local authority should be found to owe a duty of care to him. And then it was decided that it's not unreasonable to impose this duty of care where that local authority has assumed responsibility for that child's care. If that child's under your care, you're basically acting as its guardian. You owe a duty of care to them. We can also look at JD in East Berkshire. So here the parents had their child taken away from them on an incorrect and negligent accusation of abuse. So the child went into care, the parents suffered, I think, psychiatric harm as a result of this. They went through a lot. And in the court, they said that the parent's claim isn't proximate. The child holds priority. If you're sitting here thinking the child's being abused, you don't owe a duty of care to the assumed abuser. The concerns of the child will override the concerns of the parent. We can also look to educational cases, so where local authorities provide or don't provide help in their learning aspects. So in Exton, Bedfordshire, it was, I think, 9 cases, they were combined, and they basically said that the local authority failed to assess the special education needs of certain children. And the courts held that you have a discretion as to whether or not you are going to look into this. If they haven't exercised that discretion, you can't impose that duty of care. You can only wait until it has been exercised, which leads on to Phelps. So here they had exercised this discretion. They provided these education services. However, it was done to a negligent standard. So it basically says where you provide it, you have to do so properly. If it's done at a negligent standard, the courts will be more likely to find this because you've used your discretion here. Again, we can look back on the police. So Hill, understandable, it was too wide a class to impose this duty of care. And the same in Vankle, they said it was unforeseeable to use this. However, in Swinney, it's a bit different. So there was an informant. She agreed with the police she's going to inform on people in the prison. They were meant to keep her identity completely confidential, and they did. So the court says that they did do this properly. So her name was only on documents, certain documents. They were locked away in an office, I think in a cabinet, and the suspects, so the people she was informing on, broke in, found her name, and caused harm. And at the time, you'd say they took reasonable care. It was 1997. Not everything was done on computers with excessive passwords and security on it. They did all they could and all that was required of them. And furthermore, they took one more step and said that the suspects have caused the harm to the person, not the police themselves. However, you could say that this would be irrelevant if the police had failed to protect her identity and confidentiality in a reasonable manner. And again, we look onto Robinson now. So this question as to fair, just, and reasonable is no longer a consideration that we take into account. We're all equal in the eyes of the law, and we should move forward in this manner. Lastly, I'd like to look at emergency services. So these are the ambulances, fire brigades, everything along these lines. So in capital counties, the fire brigade arrived, however their actions made the fire worse. And over here they said that they did owe a duty of care because they'd assumed that responsibility. By showing up, by trying to act against this fire, you've taken in that responsibility. You are now responsible for that fire, and to make it worse clearly shows negligence in that area. We can also go on to Kent and Griffiths, which was discussed I think last lecture. So there isn't an immediate duty of care from the emergency services. The NHS doesn't automatically have to show up. However, once you've called an ambulance and they've told you, we are coming, we are on the way, failing to do so properly and failing to give an accurate time as to when they would be there, that showed that the duty of care had been breached, and the focus was the fact that they'd assumed that duty of care by saying the ambulance is coming, because we're discussing duty of care. And this is quite similar to Sharat. So I think there was this woman, she had her children in the house, but she was suicidal. Her mother called into the ambulance saying, okay, I'm pretty sure she's going to kill herself. Our kids are in the house, all these things. It was put at one of the highest levels on so they use a database, they say who's priority, so the ambulances know where to go and when. She was put up at quite a high level, and then that level was lowered without reason. There was no reason to say why they had, and they took so long. By the time she arrived, the ambulance arrived, she was already dead. And the assumption of responsibility wasn't on the fact that they said they were going to the mother. It was the fact that they reassured that mother to the point where she relied on them to her detriment. That detrimental reliance showed that assumption of care, that assumption of responsibility. They owed that duty and they failed to comply with it. Lastly, we can look at Darnley. This is quite a new case. I think the Supreme judgment just came out. So he went to the A&E, I think it was like a headache or something like that, and they told him it would be about 4 or 5 hours until he was seen. The waiting times were actually inaccurate. They misinformed him. He left, and then he suffered from brain damage. Here, the courts have basically said they owed a duty to give him the correct information. They misinformed him about the time, and that's why he left. I think so they were found liable. I think if they had given him the correct time and he just left on his own, they wouldn't have been found liable. However, they failed to do so. So looking at this, I think we can now discuss that in more recent cases, the courts are moving away from blanket immunity. They don't think it's not relevant anymore for it to be fair, just, and not reasonable. All are becoming equal in the eyes of the law. And I think if you get an essay question, you'd have to go through all of these. However, in problem questions, your main focus will be on these recent cases. So a lot of them, I think, go and read about them further, just so you make sure you know everything that you want to and you're comfortable using these cases in questions.